All right, good afternoon, everyone, and welcome to the Donia Human Rights Center lecture. My name is Tutu, and I'm the director of the Donia Human Rights Center. Today, it is my pleasure to welcome and introduce Genser, who is an old friend of mine and very, very important supporter of that Donia Human Rights Center, having helped bring in a number of speakers here, including the event yesterday with former High Commissioner for Human Rights. He is currently the managing director of Perseus Strategies, a public interest law firm, and also he's an adjunct professor of law at Georgetown University Law Center. His educational background includes a bachelor's degree from Cornell University and MPP from Harvard Kennedy School, but most importantly, his law degree is from University of Michigan Law School, JD cum laude, from
Go Blue.
Around the corner here. Excellent. So it's a pleasure to welcome him back to campus. After finishing his degrees, he went on to have a long and illustrious career, starting off as a management consultant with McKinsey and Company, and then a partner in the government affairs practice of DLA Piper LLP. And he also founded an important NGO, Freedom Now, that frees prisoners of conscience. The organization continues on. He's no longer closely involved, but he was a founding director. And as you might know already, his career has been dominated by a series of legal and political battles to free political prisoners detained by rights-violating governments. And his past clients have included former Czech Republic President Václav Havel, former Maldives President Mohamed Nasheed, incoming Malaysian Prime Minister Anwar Ibrahim, and a number of Nobel Peace Prize laureates, including Liu Xiaobo, Desmond Tutu, and Elie Wiesel. And he has worked tirelessly and relentlessly to secure freedom of those who are detained and imprisoned for political activism beliefs, and used a number of international forums, including the UN instruments, US and EU organs, print media, social media, and others to pressure violating governments into compliance with international laws. Really just looking at the UN Working Group on Arbitrary Detention, which is focus of his lecture today, he has taken more than 45 cases to there and never lost a case there. Those cases have been brought against many governments, including those of Bolivia, China, Cuba, Egypt, Iran, Iraq, Kazakhstan, Myanmar, Nicaragua, and so on. And these cases were filed on behalf of a total of 309 detainees, of whom 300 have had their cases resolved. It's a very impressive track record. And that track record of freeing political prisoners earned him the nickname, the Extractor. New York Times calls him that, so it's official.
Not to be confused with your local dentist.
Not that kind of extraction, but and his work has been recognized with many awards, such as the American Bar Association's International Human Rights Award, Liberty in North Korea's Freedom Fighter Award, and the Charles Bronfman Prize. And he's also a member of the Council on Foreign Relations, and he's a fellow of the Royal Society of the Arts. He has also published widely, both in academic and popular outlets. He has published about 200 op-eds in outlets such as the New York Times, Washington Post, Wall Street Journal, and so on. And he also has a steady flow of publications in academic presses, having co-edited the Responsibility to Protect, The Promise of Stopping Mass Atrocities in Our Times, published in 2011 from Oxford University Press, and also the UN Security Council in the Age of Human Rights, published from Cambridge University Press in 2014. And he is here today to talk about his most recent publication, this book, the UN Working Group on Arbitrary Detention, which just came out from the Cambridge University Press. So without any further ado, please join me in welcoming Genser.
Well, thanks so much, Kyo, and thanks, of course, to the Donia Center for hosting me here today. Kyo is a longtime friend. Natasha's become a longtime friend with all the work we've done together, and it's always great to be here in Ann Arbor. So I'm here today to talk about this little-known body at the UN called the UN Working Group on Arbitrary Detention. and how it operates both in theory and in practice. And so to do that, I'm going to really do 5 things over the course of the discussion this afternoon. First, explain what is arbitrary detention, then identify 5 categories of arbitrary detention according to the working group, talk about what the working group is and how it functions, talk about some of the key data coming out of its case jurisprudence, which is interesting to look at. And then I really want to bring to life what this little-known body at the UN does by telling you the story of just one of my cases, but in some detail so that you understand, in fact, that when it comes to these kinds of cases, truth is often stranger than fiction, and it's a real roller coaster ride with life and death stakes when you take on the case of a political prisoner. Let me get right into it. First, it would be helpful to understand what is detention itself. I mean, I know you all have a common idea of it from everything you can imagine, but there's a when and a how component to an arbitrary detention when a person has been deprived of their liberty. The when can be before, during, or after a trial, or if there's no trial at all. And the how, if it's going to be an actual detention and labeled as such as a matter of international law, it has to be a serious form of detention. But that wouldn't necessarily just include detention in a prison. It can include house arrest. It can include an involuntary psychiatric hospitalization and so forth. And so what makes a decision arbitrary, and how do you determine that a detention itself is arbitrary? And there's a case from the International Court of Justice that talked about the concept of arbitrariness as a matter of international law. And that decision talks about how the word originally meant, coming from the Latin, dependent on the authority or will of the arbitrator. But by the mid-17th century, the adjective described actions that appeared uncontrolled in the exercise of will, amounting to capriciousness or despotism. Today, the International Court of Justice explained, arbitrary means, quote, a decision made on the grounds of simple preference or prejudice, defying any sense of foreseeability from the free will of the authority concerned, rather than based on reason, on the conception of rule of law, on the criterion of reasonableness and the imperatives of justice, and on the fundamental principles of equality and non-discrimination. That's a very long, obviously, definition, but in short, the working group on arbitrary detention, as I'll describe in a moment, gets much more specific about what arbitrary means in relation to detention itself. So now I'm going to talk about the 5 categories of arbitrary detention. And the working group on arbitrary detention has put forward in its own manual of its activities and describing how it undertakes its operations, 5 situations in which detentions can be determined to be arbitrary. And when it issues written legal opinions on individual cases, it will classify detentions as arbitrary based on one or more of these categories. So there can be overlapping categories. Category 1 is when there's no legal basis for the detention at all. So a person who's detained after the completion of a sentence, or when there's actually no legal provision at all to justify a person's detention. Category 2 relates to cases where there are violation of fundamental rights and freedoms, and these are really the category of cases that relate to what you would commonly believe to be political prisoners. When a detention is used in response to the legitimate exercise of human rights protected by international law, such as the right to freedom of opinion and expression, religious freedom, peaceful assembly, and association. Category 3 involves violations of the right to due process. In addition to being a political prisoner because you might be detained for exercising, let's say, your free speech rights, you could also be detained in a process that is itself a violation of your fair trial rights. And so often you're talking about denial of access to counsel, not being able to present witnesses or evidence in your own defense, having a closed trial rather than a public trial, not having an independent and impartial tribunal. And the working group looks at category 3 cases and says, has the total or partial non-observance of these rights given the detention of such gravity as to make it arbitrary? Category 4 relates to the violation of rights of asylum seekers, immigrants, and refugees, obviously a hot topic today, and when they're subjected to prolonged administrative detention without being able to challenge their detention in court. And Category 5 cases relate to the right of non-discrimination. In other words, I was just talking before about the definition of what the word arbitrary means. And of course, if you're discriminating against a person and detaining them on the basis of a whole range of possible grounds, race, religion, ethnicity, gender, sexual orientation, etc., and you're detained because of your identity, then of course that in and of itself, by definition, is also arbitrary. So now let me talk about what the working group is and how it operates and functions. So what is the working group and how was it created? It was founded in 1991. It's one of what's referred to as the special procedures of the UN Human Rights Council. The Human Rights Council is a group of 47 states elected by the UN General Assembly to examine on an ongoing basis situations of human rights around the world. And that the Human Rights Council itself has created a whole group of these so-called special procedures, which include rapporteurs, independent experts, and working groups. Today there are 44 thematic mechanisms and 12 country mandates. And the working group itself was first authorized and created in 1991. Every 3 years it's up for a renewal, and it was just renewed most recently in September of 2019. The working group itself is comprised of 5 independent volunteer experts. Currently they're from the countries of Australia, Benin, Latvia, Mexico, and South Korea. They're appointed by the Human Rights Council to those jobs. They can serve up to 2 3-year terms. They meet 3 to 4 times a year, typically 2 weeks at a time. And they have a very small professional staff in the Office of the High Commissioner for Human Rights in Geneva. And they do a number of different things collectively, and this is based on the mandate given to them by the Human Rights Council. This includes issuing general deliberations about arbitrary detention policy questions, issuing urgent appeals. If there's something that, if a detainee is very sick or ill, you can make a complaint to the working group and ask for the working group to reach out and request a government to make sure the person's health and safety are being respected. It considers and adopts individual case opinions, which I'll talk most about today, and how to use those opinions to leverage the release of political prisoners. It also conducts country missions where it goes for like a week or 10 days to a country, and it meets everybody from the very top, the president, to the head of the prison system, to lots of civil society organizations and victims, to look at detention in the country and detention practices and make recommendations in the form of typically about 20-page reports about what they found and observed and what's working well and what needs to be improved. And then lastly, they publish an annual report, which is a 20 or 30-page report that summarizes their activities and all the complaints they've gotten over the last year, how many releases there have been connected to those case opinions, as well as country missions they've undertaken and so forth. Over the last 12 years, the working group has sent 1,567 urgent action appeals, and since 1991, when it was first created, it has adopted more than 1,200 legal opinions on individual cases. And I'll provide some more interesting statistics around how that breaks out, but that's over the course of its work. And I mentioned country missions. They've done more than 50 of them since 1991 to various countries around the world. So again, I'm just going to walk through this very, very quickly. It's not a complicated process. It's actually quite a straightforward process. And helpfully, because you actually don't even need to be a lawyer to take a case to the working group on arbitrary detention. You can be a victim or their family or a civil society organization. The working group itself is a quasi-judicial body, so it's not a court. You don't have to be a lawyer. There are not rules. There are what are called working methods, right? And in essence, the entire point of the working group process, as it's described itself, is to create an adversarial engagement between the person who's alleging an arbitrary detention of a victim and the government itself. And so what you see here is that you start by filing a case to the working group. It's about a 20-page, no more than a 20-page submission. The government is given 60 days to respond. It can ask for a maximum of 1 month extension. If it does respond, then you're able to reply to that submission. And then ultimately, when a case is ripe for consideration, the working group meets 3 times a year, and when there's been a submission and a response, if any, and a reply, then the working group will consider the case during its session and adopt a written legal opinion. And these written legal opinions are about 20 pages and quite detailed, walking through the information that they received and what they reviewed from all sides, and conducting a legal analysis to determine if a person's deprivation of liberty is arbitrary and in violation of international law. And you can see here what happens is that if a person's already been freed, they quote, file the case. They can say a detention is not arbitrary. They can say we need further information, or they can say a detention is arbitrary and here is why. It's worth noting as well that as a matter of course, that when and automatically, if they determine a person is being held arbitrarily and in violation of international law, that they will call for their immediate and unconditional release, and they will provide for proper compensation, an enforceable right of compensation for their arbitrary detention. So these are the 6 features of the working group that I've identified that really make it this little known but highly effective body. The first is the composition. The experts are from 5 different regions of the world, so you have a broad base of support. They're independent volunteer experts. My experience with them since I first started working with their working group, which was back in 1999, is that they do overall an exceptional job. The quality of the opinions have improved dramatically in recent years. There is one case where I strongly believe they got it wrong, which I can talk about later if you want to ask me about it, which is the Julian Assange case, where they found he was arbitrarily detained despite he having entered himself into the Ecuadorian mission in London. But otherwise, I'd say that the jurisprudence is very strong. And so having 5 independent experts from the different regions of the world is very, very important for its credibility. Next is that the methods of work are very, very helpful because although they're not strict rules, they provide guidelines for how to engage with the working group and how to go about taking a case there. And again, really the emphasis is on creating an opportunity for the petitioner, who can be a lawyer, a civil society activist, or even the victim themselves, and the government to engage in a dialogue facilitated by the working group that then results in the adoption of a written legal opinion. As I mentioned, the adversarial process is exceptionally important, actually critically important, to enable the working group to get to the bottom of the facts of the case. I will say it's important to note that if a government chooses not to respond, that does not prevent the working group from issuing a written legal opinion. It will then say, that the government has been given an opportunity to respond. Having failed to respond, the presumption will be that the facts as put forward by the petitioner are accurate, and then they will proceed to then consider the case and adopt a legal opinion. Importantly, the working group's analysis of individual cases is grounded in relevant treaties signed onto by the state and whose conduct is being examined, and other international norms and standards. So although the working group itself can't force a state to comply with a written legal opinion, this is a definitive and unequivocal legal opinion grounded in the obligations that the state actually has to comply with international treaties such as the International Covenant on Civil and Political Rights, which includes the various rights and freedoms I was talking about earlier, like freedom of opinion and expression, religion, assembly, association, but also has fair trial rights in it, right? And so when the working group is, and now there are about 178 countries out of 193 in the world, covering about 93% of the world's population that have signed on to that treaty. And so, it isn't just that the working group is making up on its own, here's why we think this detention is arbitrary, but it is saying, this state has committed to providing all citizens and non-citizens in your territory these rights, and here's why our assessment is that you have, in cases, let's say you prevail, why you fail to abide by those obligations and what you need to do to bring your actions into compliance. As I mentioned, I was just saying this, their definitive interpretation of its obligations. And then lastly, the working group has a flexible mandate and has a lot of discretion about how it goes about developing its jurisprudence and how it's accumulated expertise over time, through a mix of individual case opinions, country missions, individual deliberations, as I mentioned, on general topics. And so this has really developed a really extraordinary body of knowledge about the topic of arbitrary detention under international law. And this book took me about 3 years to write. It's about 650 pages, 6,000 footnotes, working with about 25 research assistants. And I've done the best that I can in the first ever book on the working group, to capture what one can learn from this full body of work that's been done by this little known UN body. But it's worth noting or emphasizing that especially in the world that we're in today, where there's a lot of pushback against multilateralism and there's reasonable criticism of the United Nations on human rights and a number of major challenges facing certain UN institutions, human rights institutions, let alone the fact that only about 3 or 4% of the budget of the UN is spent on human rights, when promoting and protecting human rights is one of the principal objects and purposes, one of 3 principles and purposes of the UN. Despite all of that, this little-known body has done its job well for many, many years and has enabled the release of many political prisoners around the world. And this body, in my view, is a triumph of the multilateral system. So let me just quickly run through some quick summaries of the data itself to understand how the working group has operated in practice. This was the most time-consuming part of the work. The book has 20 charts in it, each one-page charts. But it took a team of interns, externs to enter and double and triple check all 1,200 cases into a spreadsheet so that we could then capture all the data about each individual case and then aggregate it over time. So you can see here there are about 1,200 cases involving more than 5,100 detainees. So the average case, typically if people get arrested at the same time, then they can be brought as one case. And so you have some cases that have many people in it, one individual case, and some that it just has one. But you can see 65% of the cases involve one person, and you can see the other statistics here. It's interesting to note that a small number of countries represent a majority of the cases brought to the working groups. The top 25 countries listed here represent 63% of the 1,200 cases brought to the working group in its history. Although across that 1,200 case jurisprudence, there are 128 countries in the world that have had opinions rendered against them. It's important to note that this doesn't necessarily capture, the state of arbitrary detention in the world today. It's a self-selecting group. So in other words, the working group actually does have the power to, on its own accord, decide to look at a case and examine it, but it historically has never done that. And so this is how the working group has received cases, and it means that they've received more China cases than other cases, right? It doesn't necessarily mean that, although China probably is among the largest, given its scale and size and its authoritarian government, it probably is one of the largest, detainers of arbitrarily detained persons in the world today. But one can't make too much of this in terms of a reflection of anything other than how people have brought cases to them. You can see in the last, this is just in the last decade alone, and you can see 40 cases in Saudi Arabia, about 32, 33 for Egypt, China, and so forth. You can see in terms of regions of the world, the UN has basically divided the world into 5 regions. So about half the cases come from Asia Pacific, 20% from Africa, 10% from Western Europe, 18% from Latin America, and it's like I think 2% from Eastern Europe. Governments, as I said, can decide to respond or not respond to these submissions that they receive. And the response rate is down some from the first decade of the working group. In the last decade, between 2008 and 2017, it's about 48% of the time that they're responding, 52% not responding. If a government doesn't respond, this is not a very surprising outcome here. It's 93% arbitrary, 7% not. But if a government does respond, you can see that, not surprisingly, the percentage of cases that are not arbitrary or where there aren't sufficient facts to render an opinion obviously increases. Now, I was talking about the 5 different categories of cases, and so you can see here among opinions with findings of arbitrary detention, based on one or I'm looking here at one versus multiple categories of cases. And so what you can see here is that about half the cases over the history of the working group are implicated. Only one category is selected by the working group, and about a little less than half multiple categories. You can see that, and there's a reason for this, in 2008, 2017, in the last decade, the number of cases with multiple categories has increased, and that's because actually categories 4 and 5 on refugees, immigrants, and asylum seekers, as well as non-discrimination, were added in 2011. And so, although relative to the overall total, it's still a small number of cases with those opinions. Non-discrimination can implicate, and regularly does implicate, the Category 2 cases on fundamental rights and freedom. So, for example, if you're a human rights defender, it could be that you're being discriminated against because you're a human rights defender, and that would give it a Category 5 designation. But you're also a human rights defender, let's say, who's been imprisoned because you spoke out against a government at a public rally, and so you're also detained under Category 2 for your right to freedom of opinion, expression, and peaceful assembly. So we'll see more cases with multiple categories going forward. You can see here that based on opinions with a finding of arbitrary detention, the basis on which the cases were decided. Again, remember there could be overlapping categories, so this doesn't add up to 100%. But in 70% of the cases, you can see that there were, often you'll see that arbitrary detention often comes with major due process violations as well. If a government's decided they're going to grab somebody and imprison them illegally, they generally don't want to give them their rights of due process. They're trying to railroad through a show trial the outcome. So one of the things that has been very positive about the development of the working group is the time that it's taken to get a written legal opinion from the working group itself. It's gone down to about 125 days now between when a government is sent the request to respond to the submission and when the working group itself adopts a written legal opinion. So that's a very helpful development. And it's worth contrasting that with the regional human rights courts, which can take 3 to 5 years or longer to get a written legal opinion out of those courts, like the European Court of Human Rights, the Inter-American Commission and Court of Human Rights, et cetera. So this is a really fast way to get a decision that the UN has said a person is being held illegally, and this is why it can be such a powerful tool.
Has the number of cases being processed also gone up while the processing time has gone down?
I'm about to get to that. So this is reported releases. I'll come back to that question. But in the last couple of years, it's been about 100 cases a year. In the earlier years, it was about 100 opinions a year. Previous years, it was like 20 or 30 or 40. Now this is one key metric of whether the working group is effective is whether people are released after a working group opinion is published. They only really began tracking this well in the last decade, and they've tracked that 1,636 people have been, of the 5,000 I mentioned before, across 379 opinions have been released from 1992 to 2018. The numbers are obviously going to be much higher. It's just that often the family of the detainee or the NGO doesn't tell the working group. The working group didn't even formally follow up with petitioners. That process for consistently following up at the 6-month mark, the 1-year mark, only began about a decade ago. So in the earlier years, I'm sure a lot of people have been freed, but it's not captured here. Of course, this doesn't say anything about the direct correlation between the issuance of the written legal opinion and the actual release. And my experience has been that it's not often that you'll see a direct and immediate release coming from the issuance of opinion. It requires, as I'll describe shortly, combining the legal opinion with political and public relations advocacy to get somebody out of jail. So now let me talk about an actual case that I worked on to kind of bring to life what this is all about. And this is going to be the case of Mohammed Nasheed versus the Maldives. Nasheed was a dissident journalist in the Maldives who was repeatedly imprisoned by a 30-year dictator of the country, Mamun Gayoom, for publishing articles critical of the government. He spent about 3 or 4 years in prison over about a dozen detentions. He co-founded the Maldivian Democratic Party in 2003, and pressure from he and the party on Gayoom enabled the country to move forward with a process for adopting a new constitution, which they did in 2008. And Gayoom, much like many dictators, was a little bit myopic in his view and thought he would handily and easily beat Nasheed in the election. And of course, he went down in a substantial defeat in the first free and fair election held in the Maldives since its independence from the UK in the 1950s. After several years as president, unfortunately, he was pushed out in a coup orchestrated by remnants of the old regime, and ultimately Gayoom's half-brother became the president in 2013 after serious irregularities. And Nasheed, of course, didn't give up despite being pushed out in a coup, and he and his party, although at the time he was pushed out, they only had a minority in the parliament. In 2014, 2015, he built a lot more support, persuaded a lot of other pro-government party members to defect, and he was on the verge of having a majority in the parliament, which would have enabled him to be able to seriously challenge the government. And this is why Yemen felt the need to get rid of him. And so what happened was that there was this charge, a dormant charge against Nasheed from January of 2012, which in part had precipitated his being pushed down in a coup. What had happened was that the chief judge of the criminal court had been arrested by the police because of allegations of corruption made against him. Nasheed did not order the police to make the arrest, but this led to a big struggle between the judiciary and the executive, and remnants of the old regime used that to scare the heck out of people in the military and the police, as well as other corrupt elements of society, that if the judiciary was now actually going to move towards being more independent and impartial, that could have serious consequences, and this is what led to the coup itself. Back then, it had been referred to as an illegal detention, and after he was pushed out of office, there was talk of charging him with this. They did, in fact, charge him with it, but it went nowhere, and they didn't even prosecute the case. And so literally 5 years later, they resurrected this old case that had been dormant for years, and now it had been recast as a terrorist abduction. In other words, Nasheed was a terrorist who facilitated the criminal and terrorist abduction of a sitting judge. And he was arrested on February 22nd, 2015, and by March 13th of 2015, he had been summarily tried, convicted, and sentenced to 13 years in jail, as you see here. So I had actually known a very close friend of Nasheed's for many, many years and had been following from a distance what was happening in the Maldives. And that friend reached out to me and said, is this a case you might be willing to take on? And the following month, I was hired to serve as international counsel to Nasheed, as lead counsel to Nasheed, working with Amal Clooney and prominent British barrister Ben Emerson. We immediately published an op-ed in the Guardian newspaper about his case, talking about how his detention is a travesty of justice, according to Amnesty International, and to announce our presence in the case. And often, as you'll see more of, this kind of press advocacy can be very, very important in ultimately putting pressure on a government to relent. In late April of 2015, we filed our petition to the working group, and we launched the filing of that petition in an event we did with Laila Ali, Nasheed's wife, at the National Press Club in Washington. And we had to get our arms around what happened in the case very, very quickly and put the whole story together, working with local counsel, which of course we did. To quickly summarize, what did we say to the working group on arbitrary detention? We said that there was no legal basis for his detention. He was charged under a very vague anti-terrorism law, but the government actually never presented any actual evidence. He ordered the arrest of the judge himself. And so there was no person testifying. Nasheed told me to arrest the judge. There was no written documentation of any kind presented. And so literally there was no evidence at all that he even committed the crime. Yes, his government arrested him, but of course governments do things all the time, and the president isn't responsible for the decision that's made by a prosecutor and the police, especially when the prosecutor's office in the Maldives is independent. And so there was no evidence he had actually done that. And so therefore we said there was no legal basis for his detention. We also said that he was, of course, being detained for having exercised his rights to freedom of opinion, expression, association, and political participation. He was being a real threat to the government, right, by the work he was doing. And that intent was only reinforced by the rather brazen action of the Maldivian parliament, which was aligned with the president in the same party. 2 weeks after Nasheed was convicted, they adopted a law that said that people in prison cannot be members of political parties. That alone is a violation of your right to political participation, but in his case, it was meant to decapitate his being the head of his party. You have to be a member to be the head of your party, and to continue to, in essence, lead his party from within his prison cell. His conviction, of course, also barred him from running in the next presidential election, and we, of course, argued that he had been discriminated against on the basis of his political opinion. And then the due process abuses in his case were honestly shocking and ridiculous. My favorite was the fact that he was never allowed to present any witnesses or evidence in his own defense. So, for example, he wanted to present 5 witnesses, which were his chief of staff and his defense minister and all the people that were closest to him, who would all testify that he never gave them an order to arrest the judge, right? And so therefore, not only did they not present evidence that there was an order, we're going to present evidence that no one was told anything, and these are all the people that were closest to him. And the 3-judge panel refused to allow any witnesses to testify, and in their written judgment, they actually wrote, and as a lawyer, previously a law student, it was pretty impressive to see this in writing because it was just so brazen and egregious. They literally said in the written judgment, and this is very close to a direct quote, "There is no need to hear the witnesses presented by the defense because there is no way they would be able to refute the prosecution's case." So, turns out under international law, you have a right to present witnesses in your own defense, and well, they violated that too. All right, so we immediately began working with the US government on the case because previously Nasheed, as well as the Maldivian Democratic Party, has been long allied with the West and democratic countries. So Secretary Kerry went to Sri Lanka. We were able to get him to speak out about the situation relating to President Nasheed. Troubling signs of democracy is under threat in the Maldives, where the former president has been in prison without due process. That's in May of 2015. We also started working with members of Congress, Republicans and Democrats, and you can see here there was a letter where they were writing to Secretary Kerry and then the Defense Secretary expressing serious concern about the situation and urging them to call for the release of Mohammed Nasheed. In June of 2015, the Maldives announced that they were hiring Cherie Blair, Tony Blair's wife, and Omnia Strategy to represent the government. We later learned that they had been paid £420,000 for their contract. We were paid nothing. I did the work pro bono. Cherie Blair turned out to be a great punching bag, as you'll see in a moment. Unfortunately, she and her husband have a long history of representing dictatorships in his post-governmental career. Throughout the case, we kept publishing op-eds in various newspapers. So in June 2015, A Tale of Two Maldives. I was contrasting in that op-ed what the government was saying was happening in the Maldives, which was all wonderful and beautiful and fabulous and helping develop the rights of their people, versus the actual reality, which was widespread arbitrary detention, torture, and other abuses. In July 2015, we traveled both to Brussels, Strasbourg, and Geneva. For those of you who were here yesterday, this is one of the cases I worked with Zaid on, the former UN High Commissioner for Human Rights. Obviously, as you can imagine, getting a picture of the wife of our client with the UN High Commissioner for Human Rights helps enormously in putting pressure on the government. We met with the President of the European Parliament, Martin Schulz, and others. Meanwhile, a short time later, I was deported from the Maldives. I traveled to the Maldives in July 2015 to try to see my client in jail. I was told in advance I'd get a business visa. And to be able to see him, you have, of course, a right to counsel under international law, including a right to see your lawyer, international or domestic. And I arrived, and they told me that my business visa request had now been revoked, or the approval had been revoked. And so I was immediately deported to Sri Lanka, where I held a press conference. This is one of the examples of how governments overreach and do really dumb things, and you'll see more examples of this shortly. But this obviously helps enormously. I mean, being deported is like brilliant media coverage. And when you're like deporting like a decently known international human rights lawyer, it doesn't exactly send the world a message that you're treating him in accordance with his rights to a fair trial. In July 2015, the government of the Maldives filed its response to the working group petition. They made some procedural arguments claiming that domestic remedies, the case hadn't gone to the Supreme Court of the Maldives. Our co-counsel Ben Emerson at the time was the UN Special Rapporteur on the situation of human rights while countering terrorism. But that's a volunteer position like the working group positions, and he was doing this work in his day job as a lawyer. And there's no prohibition on one of the UN special procedures making a submission to the other one as long as he's not using his title and his office's resources. The government said with respect to Category 1 that Nasheed was convicted by a Maldivian court in accordance with Maldivian law, and it wasn't for the working group to consider if a terrorism charge was rightly characterized under Maldivian law. I'll come back to what of course, the working group opinion says later. But Category 2 and 5, they just simply said there was no evidence the charges were politically motivated. Full stop, that's it. Category 3, they tried to respond to a small number of these, but they didn't respond to most of the claims. For example, in response to the court's decision to refuse to allow them to present any witnesses, the government said this was just simply a matter of discretion for the trial court. Well, it turns out under international law, actually no. You have a right as a criminal defendant to present witnesses and evidence in your own defense. And while some discretion might be allowable for like how long can you question a witness, or whether in questioning a witness, whether you're asking questions that are not relevant to the actual reason for the arrest. So a judge could say, well, come on, counsel, bring it back to talking about what matters here. Like, I don't need to hear Nasheed's life story, for example. But that wasn't what happened here. In August 2015, Zaid publicly called for the release of President Nasheed. In September 2015, Amal Clooney and I traveled to the Maldives together. When I went with Amal, she helped us get in because lots of celebrities would come to the Maldives and rent private islands and things like that, and they didn't want to be viewed, I think, as rejecting that someone like her who is connected to a lot of celebrities. Of course, the government didn't know how to. The government missed every possible opportunity to argue their case effectively, and they engaged in a lot of really dumb decisions. And the next decision they made was fabulously dumb. It turns out they eavesdropped on our attorney-client privileged conversations with our client in jail. And we knew this because we'd gone to talk to Nasheed, and this is all now public now, not privileged anymore, but at the time, things were getting pretty bad in the Maldives, and his wife and 2 young kids were still living there, and he had privately said to us, or we thought privately, although we assumed we were being listened to, but didn't think it would be so obvious so fast, but he had said to us, can you please tell my wife that I really want her to get out to the UK as soon as possible and claim asylum there for her and the kids, because I'm afraid of, there were like lots more protests in the streets with him detained, and there was violence and other bad things going on. And literally we're 10 minutes away from Mafushi prison, the island prison he was on, in our launch heading back to the main island of Mali. And I get a phone call from Lila on my phone saying, "What's this about, my husband wanting me to go to London?" And I said, "Well, that happened fast." And she explained to me that there was a senior person at the prison whose wife was a good friend of hers. That senior person at the prison, called his wife and told her that what had happened in the conversation. And then the wife picked up the phone and called, Lila Ali, because they were friends, saying, "Hey, I hear you're leaving." So it doesn't hurt our cause, again, that we're being eavesdropped on. A short time after that, the very next day, in fact, we had a great editorial in the New York Times. A Maldives leader unjustly detained. We've been working with them for a couple of weeks on that, and we were able to kind of trigger that to move forward based on the news coming out about us being eavesdropped on. 3 days after that, in his annual address to the UN Human Rights Council, Zaid talked publicly again about the detention of President Nasheed. There had been a brief moment where he had been transferred to house arrest, and they claimed that he'd spent his imprisonment under house arrest, and then they reversed themselves and said, "No, now we're taking him back to jail." So, again, talk about dumb moves, it just draws more attention to you. By the end of September 2015, we won the case at the Working Group on Arbitrary Detention, and of course it found he was being held illegally and urged his immediate release. The Working Group said he was being held in violation of international law on all the categories of the case that we had submitted. It said he should be released immediately and given a right to compensation. The Working Group rejected the procedural arguments. The Working Group has said repeatedly, you don't have to go all the way to the Supreme Court of a country to bring a case. It's okay if you've just finished the trial. They didn't find any conflict of interest with our co-counsel. On category 1, they said, and this is quite strong language from the Working Group, it was clearly impossible for the government to evoke any legal basis justifying the deprivation of liberty of Mr. Nasheed. In simply producing a list of witnesses and evidence in its response, the government failed to rebut the assertion that there was no evidence produced at trial. So they just listed, like for example, news interviews. They claimed Nasheed had said that he admitted that that he arrested the judge, but the news articles didn't actually say that. Anyway, that was category 1. Categories 2 and 5, it concluded the detention resulted from the exercise of his right as a political opposition leader to express his views contrary to the government. There's a lot more to it. They talked about specific factors that led them to reach this conclusion. And then, last is category 3, not 2 and 5, my apologies. And they concluded that the detention resulted from the exercise of his right as a political opposition leader. I'm repeating. My apologies. This is the first time I've presented this, so I will fix this next time. But the due process abuses were egregious, and they listed all of the egregious due process abuses that had taken place. And as I said, the government didn't respond to most of them. So when a government doesn't respond, then that's viewed in essence as an admission that the information presented was accurate. The government at this point was floundering all around as we were beating the heck out of them. And first on September 27th, it was announced that they had actually found, my team and I found, a filing by the Podesta Group with the U.S. Department of Justice, where if you represent a foreign government, you have to file papers to show that you're going to do that with the U.S. government. And they had filed a contract that showed that they had just been hired for $300,000. And literally, the Maldives is like 8 hours ahead, but the next morning in the Maldives, they're denying that they had hired the lobbyist, even though it was in writing in a filing with the U.S. Department of Justice. The pressure was mounting. Amal and I were labeled enemies of the state because when we launched the submission to the UN, when we launched the UN opinion, which found he was being held illegally, we called for targeted sanctions to be imposed on grave human rights abusers in the Maldives, including the head of the prison system and a range of others. And so they wanted to kind of criminalize it. Again, this shows kind of a lack of common understanding about how to fight people like us internationally. But the head of the parliamentary group that was in the majority party, the president's party, called us enemies of the state in a speech he gave, and I responded by saying I was proud that he called Amal and me enemies of the state, and he thought I just simply misunderstood that this was somehow, I thought it was a good thing, and it really, really was a bad thing, and he says, indeed, you two are enemies of the Maldives. And I was like, well, it only helps when you keep talking and saying stupid things like that. So meanwhile, we kept up the pressure on the government through the media. Again, more op-eds. The European Parliament adopted a resolution urging his immediate release, citing to the working group opinion. So this is what I mean about instrumentalizing the working group opinion. When the UN says a person is being held illegally, then everyone else around the world that we're getting to help us, we want them to be saying in what they say, the UN has called for his release as well. Another Wall Street Journal op-ed, human rights crisis racks paradise. We don't make the titles, they do that at the Journal, but another strong hit there. It didn't help matters that there were some funny things that came out. It turns out the Cherie Blair's person had first pitched to represent Nasheed and had said Yaman is a dictator and all these kinds of things. And our team had been overwhelmed with people offering to help, and they talked to a lot of people and they'd forgotten about this, and then they discovered it later and they sent me the copy of the pitch. And so we had such a fun time, like blasting, the government's lawyer, who in the pitch said Mr. Nasheed took the Maldives on the first step towards true democracy, and then his arrest and trial is a politically motivated show trial aimed at cementing an authoritarian regime. And that's what the government's own lawyer said previously when he wanted to represent Nasheed. He declined the representation when he was told he couldn't be paid, and obviously went for the money. But of course, subsequently, the same guy, Toby Cadman, said that Nasheed's trial was in accordance with international standards. And in the UK, it would constitute an offense of kidnapping and false imprisonment for which the maximum penalty is life imprisonment. So it's so fun to be able to juxtapose a person's words, pitching the other side, while then coming out later and saying, well, which Toby Cadman do we believe? In early 2016, we launched a major report calling on the U.S. to sanction key perpetrators. We saw, Secretary Kerry, Senator McCain, Nancy Pelosi, and others. We had an op-ed in the Washington Post, again, keeping the pressure on. And at this point, the pressure just became too much for the government. Over the weekend of January 16th to 17th, 2016, initially Yaman said he was going to release Nasheed. And then we got word he had changed his mind and wasn't. Then he changed his mind again after I was able to get Secretary Kerry to call and leave a message for Yaman, who wouldn't answer the call. And we were able to get, of course, Nasheed to the airport, and I orchestrated a phone call from Secretary Kerry to go to Nasheed at the airport, that we could have our team on the ground take a photo of him on the call with Kerry, and then I was able to tweet out that he had just spoken to Kerry as a shot across the bow of the Maldivian government and to Yaman, you better be careful if you're going to reverse your mind a second time. And then Nasheed flew to Colombo, Sri Lanka, and then on to London, and this is the image that I videoed with my own phone as he arrived on January 19th, 2016. So this is one of those airport moments which makes all the hard work worthwhile, as you can imagine. It was a joyous day. Nasheed did a quick interview there with a bunch of journalists present, and this was a great moment that was captured. He said, "Why do you think you're free today?" And he looked at Amal and me and he said, "Well, obviously I've got great lawyers." And so he then burst out laughing, and that was this shot that was caught. So this was just the beginning of a new chapter in President Nasheed's struggle to restore democracy to the Maldives. Literally, like 2 days later, we met Prime Minister Cameron in number 10 Downing Street. Cameron had been friends with Nasheed for many, many years and had been very helpful. It wasn't over for Cherie Blair either. It turns out that that £420,000 was money that had been stolen from the treasury of the government of the Maldives. And she, of course, should have known this because she didn't get a wire from the government of the Maldives. She got a wire from some random dude. And the random dude, it turns out, was a guy who was very close to the vice president, and the vice president of the country, who was later pushed out of office and is now sitting in jail, stole about $80 million from the government. And he had given this guy about $5 million, and he was the one who had hired Cherie Blair, and he didn't want to go get some kind of approval to pay Cherie Blair, so he just told the guy who had just given $5 million to for whatever he was doing to help the government, hey, can you give her the £420,000? So, whoops. And then there were mass protests in the street about Cherie Blair, shame on Cherie, waving placards. This is all after Nasheed is freed, by the way. Later, we had confirmed what we knew was obvious. The former vice president himself, in fact, told the Supreme Court, as he was sitting in jail trying to get a better sentence for himself in the Maldives for a lot of other corrupt activities, that all three of the judges were paid off about $100,000 each to rule against Nasheed. I mean, we knew that was the case, obviously. We didn't know how much they were paid. In April 2018, another body at the UN we'd taken Nasheed's case to ordered the Maldives to requalify Nasheed to run for president. This is on the basis of the fact that a disqualification to run from office based on an arbitrary detention is in fact also illegal. And we'd hoped he'd be able to run. Yaman, of course, refused to allow him to run anyway and ignore this binding legal opinion. So Nasheed had to recruit a very good friend of his to run for president. In September 2018, Ibrahim Mohammed Soli was elected president. So not so just last year. On November 1st, 2018, after the election, Nasheed came home to an extraordinary welcome. You can get a sense of what life was like on that kind of extraordinary day where he came back, having helped orchestrate the defeat of Yaman and put in place a good friend of his to become president. In November 2018, the Supreme Court of the Maldives reversed his conviction, but you can see in the on the right that literally a year or two earlier, the same Supreme Court had upheld his jail sentence. So let's just say that justice is somewhat malleable in the Maldives. I also met President Soli myself for the first time in person in November of 2018. And as I said, from an enemy of the state to meeting the new president, 3 years later, an honor and a privilege. In April 2019, Nasheed was elected to the People's Majlis, their parliament, and on May 28, 2019, was elected the Speaker of the People's Majlis. And to bring it all full circle, just actually a couple weeks ago, I was there in the Maldives and gave Nasheed a copy of my book. And you can see he tweeted out that the working group opinion had a big impact on helping get him out of jail. And so lastly, this is one of the quotes that most inspires me in the kind of work that I do. Mahatma Gandhi said, "First they ignore you, then they laugh at you, then they fight you, and then you win." Thank you. Happy to answer questions.
Maybe I'll start off with a few questions. Thank you, that was fantastic.
Probably more than you ever wanted to know, but
well, yeah,
I try to cram a lot in.
We learned a lot. First, in your figures that you showed about the countries that are a target of working groups' work, Russia wasn't there, and then East Europe has very few PI. So I'm wondering if you could comment on why
Sure.
that is. And then the second question is about the place. If you could situate this particular working group in the big pool of other working groups and special rapporteurs in the UN, because this seems like a pretty effective, right? Listening to you and looking at the numbers of people freed. So I'm wondering if you could say a few words about where it situates in terms of the efficacy of other UN human rights instruments. And finally, about this particular case of President Nasheed. So this working group's procedure and decision seemed important, but you also used a lot of other methods, going to the media, op-eds, talking to, going to the State Department, talking to other politicians in the US, UK. So among the methods that you used, how important was this particular body?
Yeah. So let me, I guess, answer those in turn. In terms of Russia, Russia actually only has about 4 or 5 opinions over the 1,200. My experience talking to Russian human rights lawyers, because I've done a Russia case myself, is that some of the most effective Russian human rights lawyers really don't speak English. And the official languages of the Office of the High Commissioner for Human Rights, are French, Spanish, and English. They can receive communications in other languages, but then they have to be sent out for translations, and it takes a very, very long time. And the reality is that most domestic human rights lawyers in Russia aren't aware of the working group and don't really have any easy way to become aware of it. I'm looking to get the book obviously translated into Russian, so that'll be more available. So again, it reaffirms that the working group is responding to what it receives, they're currently about 200, 250 political prisoners in Russia today. And so obviously more of them should have opinions issued finding those detentions to be arbitrary and in violation of international law. In terms of where the working group sits within the special procedure system, so as I mentioned, there are about 50 of these different rapporteurs, working groups, and independent experts. The working group on arbitrary detention is the only body among all of these special procedures that actually issues written legal opinions and adjudicates cases in this manner. So there are a lot of other thematic rapporteurs. Let's say the special rapporteur on the right to freedom of opinion and expression, the special rapporteur on the right to peaceful assembly. You can lodge a complaint with those special rapporteurs if you or your client have been a victim of interference with that right. So I could write a complaint to the Special Rapporteur on Freedom of Opinion and Expression that I tried to publish an op-ed in a newspaper and then, it got denied and then I got detained or whatever, right? And what happens in those circumstances is that Special Rapporteur will write to the government and ask for, saying, we received this allegation, what is your response? And then as part of their annual report, they will categorize how many of these kinds of complaints they got, how many were conveyed to governments, and then all this ultimately gets made public. The summary of the complaint, not who sent it, but the summary of the complaint and the response of the government all gets made public eventually, within a year of basically this all happening. But it doesn't have the same weight or value because it's a private process, which is only at some point much down the road made public, and the government is asked to respond to a narrower set of things, and it replies, and the rapporteur doesn't then analyze what they received and what they got from the government to render any opinion about it. They're really playing a facilitating role, which is to kind of bring to the attention of the government that this allegation has been made and what is your response. And so this is why, in my view, this particular working group is one of the most effective, because although these other rapporteurs and working groups and experts do sometimes issue public statements where they call for the release of a political prisoner or where they highlight a particular situation, the public statements that can be more directive, calling somebody, saying that what's happened to somebody has been a violation of one of their fundamental rights and freedoms, that's a very small percentage of the overall caseload, and so therefore most of the complaints going to governments from this set of experts is of the kind that I've just described. And then lastly, you asked with the Sheeds case, where did the working group opinion fit in? The working group opinion was actually incredibly important. And it is often the case, especially even more important when a government does respond, as they did here. Here we were able to just hang them by their intransigence and they put themselves really far out front in ways that were really unadvisable. And made a lot of mistakes, as you could see. But one of the major mistakes they made was, Cherie Blair and Toby Cadman coming out and saying, we're going to win this case, et cetera. I could have already told you in advance that they were going to lose, right? And so either they didn't know the body well or they were just posturing, but they were setting up their client for a big fall. If I had been representing the government, I would have said to the government, either let's not respond at all, because not responding, although you're still going to lose, you can say, well, we didn't participate in the process, we don't consider it valid. And then at least you have that argument, which is not a great argument, but it's better than having participated and losing. Or I would have said, if we're going to speak publicly about this, then let's downplay expectations and say, the reality is, all that really matters is Maldivian law and the Constitution, and let's make that argument and say this was valid and appropriate. But they built up the importance of the working group opinion by having had a press conference when they responded to us and having put out all these public statements with all this bravado, which of course, by the way, was, I'm sure, what their client was asking them to do. But if they had been providing good advice, they would have not made it such a devastating defeat when they got shredded in terms of the working group opinion. And so we included reference to the working group from the moment we got that opinion. Everywhere we went, all the media, all the political advocacy, everything over and over and over and over again was hammering that the UN found him to be held illegally. And it's incredibly valuable as a tool because it's not just his wife saying he's being held illegally or me as the lawyer with Amal Clooney and Ben Emerson saying he's held illegally, but now we've got the whole UN. And it's less important in this case because this is a high-profile case where it was patently obvious he's a political prisoner to everybody that was looking at the case objectively. But in lower profile cases, often dictatorships are much smarter than this one was. So for example, I had a case in Turkmenistan where two Turkmen journalists, were driving down the road one day. They were anti-government, reporting the truth and therefore characterized as anti-government. And they get pulled over by the police, and they literally, the police ask them to step out of the car. They're asked to open their trunk. There's nothing in the trunk, but then the police come and load a bunch of guns into the trunk, and then take photos and say, "We found guns in your trunk," right? And charge them with weapons offenses, right? And this is what the smarter dictatorships will do. And so in those circumstances, even well-meaning human rights groups aren't going to jump both feet into the case until they vetted it carefully and thoroughly. And because there are allegations of weapons offenses, it slows down international support for those people. And it takes a lot of work to try to get to the bottom of what happened and to hear their side of the story, and then to cobble together all the people that have known them over their whole lives to lay out what happened. It turns out Turkmenistan had done this a number of times before, so we were able to bring that to bear. But the full-throated advocacy from the international community really didn't begin at all until we won the case at the working group, because the government kept saying these guys had illegal weapons, and our response was, well, that's not true, but it's even if it's a dictatorship, people are very careful because if it turns out they were their weapons, they don't want to be on the wrong side of it. So working group opinions can be especially important in cases where the facts are more complicated. But in this case, because they made such a big deal out of having hired Cherie Blair and having gone this route of fighting this directly, when they lost, it was devastating. In fact, I heard, because Nasheed knew many people in bureaucratic roles that remained in the government that weren't political appointees, and so we heard lots of information about how, like, Cherie Blair was called by Yaman and she was screaming, he was screaming at her, like, why are we paying you all this money? How could you lose? You promised us you were going to win. So, I mean, it was very gratifying at the time to hear those kinds of stories coming back. But again, if they had been better lawyers, they would have realized that the likelihood of their prevailing was not high, and they would have managed expectations accordingly.
Hi, my name is Haya. I'm a senior studying international studies. So you talked a lot about how international pressure plays a big role and how using the framework of the state's dedication to rights or due process or whatever, that's how you kind of tackle these cases. But how does the working group and a defense team deal with countries in the middle of conflict? So for example, Syria or North Korea, where the rule of law seems to be void and they don't care about international pressure. That's Europe and the US aren't going to make a difference.
Yeah. Well, I mean, look, the reality is that working group opinions mean more or less depending on the country we're talking about and the ability to combine those opinions with leverage that matters to those governments. When I'm a process expert, not a country expert, although I'm an expert maybe in a handful of countries that I've worked in the most. But the reality is when you come to each new country situation and you're looking at the situation, you have to ask yourself, what are the 20 or 30 things you could do to help a person, legal, political, public relations, and how you sequence them to have a maximum impact. And undoubtedly, there are certain country situations that are very, very hard. I mean, I took on a case of a North Korean in a North Korean gulag. We still don't know if he's even alive. We won the case of the working group, but that's of little kind of consequence in terms of the ultimate outcome. It's incredibly hard going up against North Korea on even a foreigner case, let alone a North Korean case, when there's just so little information coming out. So obviously, the value of the working group opinion in those kinds of cases are more for justice and accountability purposes and for documenting and seeing the international system speak with a single voice about the nature of in that case, the North Korean gulag and the disappearance of the father, with no due process of law, no criminal charge and otherwise. And we were making a broader point about the North Korean gulag system by having that case come out. But of course, when I was asked by the son, who had actually been in the gulag himself and had escaped many years earlier, to take on the case, I made it clear to him that there's only so much we're going to be able to do here, and that we're not going to see probably any information in near term about what's happened here. Obviously things can get worse for a person also when the working group gets involved, and so this is also something you advise your clients on, the pros and the cons of taking a case to the working group. But in that case, it had been almost a decade. The guy didn't know if his father was still alive. He had only learned about the working group through someone who knew me, and he said, I have no hope. My family has no hope. At least if the UN says he's being held illegally, then that will have some comfort for us, that at least the injustice has been recognized. And the greatest fear of any political prisoner I've ever represented is to be forgotten. Obviously, this person, if he's still alive, would have no idea that the working group came out with this opinion. But I think for the family that had to live with him being disappeared into the gulag and not knowing whether he was alive, there was at least some comfort for them provided by the working group opinion, which at least documented what happened to him as a matter of record and as a matter of the international system acknowledging the arbitrariness of his detention. Those cases are especially hard, and it's tough to those are some of my unresolved cases that will never be resolved, at least not in any near-term sense.
Thank you.
So I noticed through the case study that you had stories in the Maldives Independent,
Yes.
and I was a little surprised by that because I imagined that the local government would have not allowed for that type of freedom of the press from local outlets, and so I'm wondering how common it is for you to be able to find an independent source in these countries when you're pushing for. your
So the other. Although most of the work is in Dhivehi, their local language, I also did regular interviews with Raja TV, which was the one independent news broadcasting station there that broadcasts nationally. And Raja TV, over the time that I was representing Nasheed, was at various stages shut down temporarily, journalists imprisoned and these kinds of things, but then allowed to continue to broadcast, in part because of international pressure being brought on the government. The Maldives Independent, over the time that I was working with them, was at that point only a web-based publication. It had been forced to stop physically publishing. They're now back to physically publishing, obviously, with the changes that took place. So it really, again, depends on the country and the situation. The reality is you don't, there aren't a lot of countries, among the 100 or so dictatorships in the world, about half of UN member states, you go from the totalitarian, like a North Korea, to the authoritarian, to the semi-authoritarian, to the, appearance of democratic, but not actually democratic. And there's a wide continuum. It's only really on the far end of totalitarian to severely heavily authoritarian that you have no independent outlets. Now, are they widespread and easily available? No. In China, obviously, which is heavily authoritarian, there are ways to get around the Great Chinese Firewall. In the last decade, although the repression has increased dramatically, so has the access to information for the average Chinese person, so they can access this. Of course, you can't publish physical newspapers in China, and you can't have television studios where you're broadcasting things that are adverse to the CCP, but you can still get information out, to various people and otherwise. So again, everything is kind of fact specific, but some of the best interviews I did, or the most important interviews I did, were talking to Raja TV to be broadcast nationally. It made me very well known in the Maldives. In strange ways. I guess the further you get from home, the more admired you are. But when I went back there in November of last year, and I was standing by Nasheed after the Supreme Court decision was announced, I had easily 30 people wanting selfies with me. I was recognized on the streets. I stand out in a crowd there, as you might imagine, but literally at the airport, people recognized me and came up to me and thanked me for what I had done. And so it's pretty extraordinary, actually. Maldives is a small country, and there was only one TV station to watch, so that was pro-democracy focused. So I did literally probably 30 interviews on national television in the Maldives, and I was always doing and saying the things that many of the local people wish they could say and do, but they would get arrested if they did it. So I would go right at the foreign minister and call her a liar, intentionally using inflammatory language. That's accurate, but I don't just call a person a liar and use epithets, but I then explain, here's why what she said is actually a lie, right? So but to be able to do that, was a luxury that most people in the country didn't have. And so I became quite admired for that exchange I had with Ahmed Siman, when I said I was delighted to be an enemy of the state. And the guy actually took the bait and responded. I have a huge number of Twitter followers that are Maldivians. If I tweet out something on the Maldives, I'll have hundreds of likes and retweets and all that. So it's one place in the world where I'm always welcome, at least now. First deported, then welcome. Hope it doesn't change.
Thank you so much for your work and that great presentation. I was wondering a series of questions. The first one is, how often, in terms of percentages, is arbitrary detention justified in terms of counterterrorism or anti-terrorism? Do these public relations firms and lawyers that typically defend autocracies use that as their primary justification? And is part of the defense consistency, i.e., the United States does this on the same grounds. Why can't this state do it on the same grounds? And how strong, if that is the argument, how strong do you think that argument is?
Sure. Well, all very good questions. So, the book itself has a good chunk of the substance in here in the due process section relates to arbitrary detention in the context of counterterrorism operations. The working group has not often done this, but occasionally will look at broader mass detention situations. And in fact, in 2006, did a big report on Guantanamo with a number of the other special procedures, tried to visit Guantanamo. They weren't able to. They were able to meet with a lot of Bush administration officials back then. And they issued a rather scathing report about the ways in which the fact that most of these people were victims of an extraordinary rendition. And if you're the victim of extraordinary rendition, it doesn't matter what happens when you get to that country you've been rendered to. It's prima facie a violation of your rights under international law. And so you're arbitrarily detained regardless of if you had the best due process in the world. And so, working group basically eviscerated the Guantanamo system as violating the rights of criminal defendants, not only extraordinary rendition, but obviously lack of access to counsel or counsel's access to evidence, lack of ability to actually access an independent and impartial tribunal, let alone have a public trial, and all these kinds of violations. The United States got very upset. President Bush, State Department got very upset, of course, about the report. I mean, to me, it was really non-controversial, actually. I mean, international law is quite clear in these questions, and these are clear and unequivocal violations of the rights of due process of criminal defendants, starting with extraordinary renditions. But there's also a whole body of work of the Working Group on Arbitrary Detention of jurisprudence that relates to military tribunals, and oftentimes you'll see civilians tried before a military tribunal, with much more summary trials that aren't consistent with international standards, and so there's a whole body of cases around that as well. There's a lot of extraordinary rendition alone, without even the rest of what might come with it. And so this is definitely a kind of a good chunk of cases, probably 150, 200 cases of the working group. And again, to me, this is one of the least controversial areas. Of course, the argument is that this is all in the name of, protecting people, from terrorist activities, and there are arguments being made that these are unlawful combatants rather than detained in war rather than given the rights of criminal defendants. At the end of the day, any state can decide our system of justice is sufficient that we can, if they're terrorists, we should be able to present the evidence to a court and give, maybe some of it's in camera if it's sensitive with sources and methods, but we should be able to put people on trial that are in Guantanamo in a court in the United States, and if they're really guilty of committing serious crimes, then we should be able to present the evidence, let them challenge it, and see what a jury says. Of course, a lot of people in Guantanamo were tortured either in black sites or through the extraordinary rendition, and so a lot of the evidence obtained wouldn't be admissible in an ordinary court. And of course, in a lot of these cases, people are detained. There are lots of examples of this, based on hearsay, double hearsay, triple hearsay, again, not admissible in a court of law. We famously had for years these several Uyghurs from China who got caught on the battlefield basically, but had done nothing wrong, and then ended up sitting in Guantanamo for years, with the U.S. government refusing to allow them to be free, and in part because they had nowhere to go, because no country in the world would take them, because China was putting a lot of pressure, and the U.S. wouldn't let them go to the United States, and so they just sat for years in Guantanamo, where even the U.S. government said they'd done nothing wrong, yet they're sitting in Guantanamo for years. So, governments definitely will make the argument to me as I meet with governments on these kinds of cases, especially in that context. Well, the United States does this and this and this, and my response to that is, I'm deeply troubled by what the United States does, but I'm not representing someone in Guantanamo. I'm representing someone who's in one of your jails. But I can assure you that I'll hold the United States to the exact same standard I want to hold you to. So, there's not much they can say to that. Undoubtedly,
They could say, well, this is the customary law.
Well,
That's what everybody does.
yeah. I mean, I think so. So what's interesting is that states are not arguing. Well, states are not arguing that the rules don't exist and they're not bound by the rules. They're arguing that in some twisted way that somehow what they're doing is consistent with the rules. And here what we're talking about is not customary international law. We're talking about treaty law, right? So treaty law is binding, but also customary law is binding. But treaty law is very easy to understand and interpret. For example, in the International Covenant on Civil and Political Rights, there's a 20-member expert body elected by the states parties that interpret what each provision means. Like each of the provisions of the ICCPR have what are referred to as general comments, like 30 pages, elucidating what does the right to freedom of opinion and expression mean, and what is and isn't, and how do you look at an individual situation, et cetera. So you can't, you couldn't respond as a legal matter to an argument that you're violating treaty law, which is very plain on its face about what's required, like a public trial, like access to counsel, like access to evidence, presenting witnesses, and say, well, the custom is against that. You signed the treaty is binding in all circumstances. You can try to argue that certain provisions, for example, there are limits to freedom of opinion and expression, right? If it's, the old adage of, yelling fire in the crowded theater, right? But if you want to make those arguments, you have to argue why one of the exceptions to freedom of opinion and expression applies. But when it comes to due process rights and the rights of a fair trial, there aren't exceptions that are substantial within the rights to a fair trial that are present in the treaty. And so we're not arguing about customary law, we're arguing about treaty law, and treaty law is very straightforward on these questions. So, again, governments will come up with excuses all the time. The US government actually tends to win a lot of cases, interestingly enough, at the working group, in part because not a lot of people take cases to the working group. The Guantanamo cases, and there have been like, not just that one report, but probably 15 or 20 cases where the US has lost all of them. But often people will lodge a complaint on behalf of an immigrant, and international law does allow for the detention of migrants and refugees for limited periods of time, and the cases, at least that have been brought against the US, have not been for people detained for long periods of time, but for short periods of time. And so the working group has said that this is within the margin of appreciation for the detention of a refugee or asylum seeker.
And one quick follow-up.
Yeah. Oh. Okay. We'll come back. Well, quick follow-up, go ahead.
My understanding is that the treaty law is for human rights law. And then when the US objects to that, they say, well, we're not in a human rights regime here. This is kind of like a war regime, but it's not full-on war, and therefore that treaty. So the question of the exception is, when is the exception invoked? And what they're going to say is, yeah, there's treaty law, but that isn't jurisdiction in this particular domain.
Yeah. Well, I think that the argument the US made, which is just sort of outrageous, their actual argument was was both that, but also the argument that somehow international treaty law doesn't apply extraterritorially, and people in Guantanamo Bay, Cuba, are not in the United States, and therefore what US forces are doing outside the United States shouldn't be covered by international law. That's a specious argument. You're responsible for what your agents do around the world, and if you do an extrajudicial killing in a foreign country, the United States is still responsible for an extrajudicial killing if CIA operatives were to murder somebody abroad, even if they're not in the United States. But in terms of arguing the whole issue of the laws of war argument, the problem that you have making those arguments, if you look at the Geneva Conventions, is in most of these cases, there's no evidence these people were actually combatants, right? You had like Osama bin Laden's driver famously was like one of the people there. Well, he wasn't shooting and killing people, and you had a lot of people who, based on double and triple hearsay, were told that they had, done something. But again, there was no direct evidence of it. And so, undoubtedly prisoners of war have more limited rights than political prisoners or other detainees. But in the case of, a lot of the people that we're talking about that ended up in Guantanamo, these people were not, soldiers of a foreign nation, or most of them were not even members of terrorist groups. So the US is trying to kind of bootstrap a general argument about where in this global war on terror, and therefore anyone we pick up as we're conducting the global war on terror must be an enemy combatant. And that's a dramatically overbroad argument that doesn't work and isn't consistent with the Geneva Conventions. You have to make a specific case as to why this specific person, on a case-by-case basis, is in fact a combatant, not a general case that any activity we undertake abroad and anyone we find in the field is therefore a prisoner of war, when you don't have any evidence that they were a member of a terrorist group, member of a military, undertaking armed action against you. It gets more dicey and challenging with respect to terrorist groups because it's harder to know who is a member of a terrorist group. A soldier is much easier to identify in terms of the laws of war. But the problem that the U.S. has had with the argument that it's made is they keep making this argument, but they've never been willing to reveal to the international community the evidence that they have that makes them justify why we have concluded this person is a prisoner of war. So, I think one of the most important things when it comes to international rights of due process is your ability to understand the evidence against you and to be able to challenge it. And so these are conclusory statements made by the United States, having provided no specific justification for any of these individual people, claiming intelligence sources and methods, and we've just concluded, based on our own considerations, which we will not make public or share with anybody, that these people are prisoners of war, and that's just not the way that the Geneva Conventions work when it comes to prisoners of war. You have to identify the prisoner of war, you have to say what they've been doing and where they've been doing it, and you have to make the legal argument as to why they qualify as a prisoner of war, and the U.S. has not done any of that. We've just, at the very high level, said they're all caught up in the battlefield, therefore they're all prisoners of war, and our own considerations as to how we reached that conclusion we're not going to tell you. And the problem is, although we're now down to almost, we had hundreds, almost 500-600 at Guantanamo, we're down to like 60 or 80. But it turned out, as people started to be released from Guantanamo and relocated, that it turned out that all those public claims that were conclusory with no evidence with respect to those that have been freed were actually false, repeatedly false, right? Where somebody just gets grabbed by accident, and the US government's acknowledged it was a mistake. So when you have said this as a high-level proposition, and then hundreds of people are freed, that if they were, if they had good evidence, I'm confident the U.S. would have prosecuted them, either in a military tribunal or in a court, and we didn't prosecute them, and in many cases we acknowledged that they weren't guilty of anything, and that they just were in the wrong place at the wrong time. So again, it undermines any general argument you're trying to make when you still don't have a lot of specific cases where you're able to, refer to these people as prisoners of war. Sorry, it's a long, we could write dissertations about this, so sorry. Yeah, please.
Yes, thank you for the presentation. You mentioned the Guantanamo cases and also some to do with the immigration regarding the U.S. There were about like 15 or so cases, I think, apparently against the U.S. I think in the chart you listed in the presentation. I'm wondering, are there other sort of substantive issues that those have dealt with outside of Guantanamo and immigration? And I'm especially interested in the issue of targeting of, I guess, treatment of whistleblowers in the U.S. In recent years. And just one other thing is, have there been, I guess, treatment of members of the panel by the U.S., sort of targeting of them, sort of similar to what has happened to justices on the ICC, where they've been, like, had their visas revoked? So just those, or other similar difficulties? Yeah,
so the bulk of the cases against the U.S. have been Guantanamo or terrorism related, Guantanamo terrorism related and immigration related. I can't think off the top of my head of any other case that was, on simply a person that it was alleged that they were in fact, arbitrarily detained. There was a high-profile Cuba case actually, which is known well here as well, of 5 Cuban detainees in the United States who were government agents that were referred to as the Cuban Five, who had been spying on U.S. NGOs and in certain cases on U.S. military facilities, who were convicted in an environment in Miami when they were arrested that was, while it was an open trial, all the media coverage was pretty harsh and negative, and obviously there's a strong anti-Castro sentiment down in Miami, anti-Cuba sentiment, and so the arguments were made, and the working group agreed that that the violations of the rights of due process were sufficient as to make the overall detention arbitrary. But again, there are not very many U.S. cases on that in that score. When it comes to, I'm sorry, what was the last point you said? Regarding whether there's been pressure on whistleblowers and the working group. Yeah, so there have been a number of whistleblower cases at the working group of whistleblowers who have been detained, not related to the United States, but the working group is generally found in their favor if there's good evidence being put forward on behalf of whistleblowers. It's discriminating against them on the basis of their freedom of opinion and expression. And freedom of political participation. When it comes to the targeting of the working group members themselves, other than blocking the working group from visiting Guantanamo, there hasn't been a direct targeting of the working group members. The working group, in fact, has previously visited the United States, and there's one of their country missions was to the U.S. A number of years back, and not so long ago, actually, 3 or 4 years ago, I think. The working group traveled to about 5 different states and looked at federal prisons, state prisons, met with judges, federal, state, met with prison officials, met with the U.S. Department of Justice, Bureau of Prisons, and issued a really interesting report on U.S. detention practices. They obviously commented on a lot of the things that we all know about well, which is disproportionate minority detentions in the United States relative to overall population, and problems of racial discrimination in our legal system. Lack of access to legal counsel, as well as death penalty, of course, is a big deal for the UN and the international system. So a lot of concerns about the death penalty, and a lot of concerns in U.S. detention practices relating to extended solitary confinement, which is over time, it starts as cruel, inhuman, and degrading treatment. It can become torture if extended for lengthy periods of time. In California, famously, but a number of federal prisons, like supermaxes, have permanent states of solitary confinement, which constitutes torture as a matter of international law. So this is sort of how they looked at the U.S. But no, the working group has not been directly targeted for retributive action by the United States.
Thank you, and thank you for your work in particular. I joined Amnesty International when I was an undergraduate at the University of Michigan, and I was always so happy with their methodology of essentially finding a government that they would write letters to and, essentially shame the government into releasing somebody, which is a lot of what also you have described with the power of the international media here. But eventually I learned that what governments had also learned was that they could bypass that by not putting people in prison, because if you put them in prison, they're there long enough that they become Amnesty International prisoners of conscience, and then everybody knows it. And so now what they do, instead of doing that, a lot of the time is they bring them in, they beat them up, they send them back home. A couple of weeks later, they bring them in again, they beat them up again, but they don't actually put them there so as to not kick into the here's an amnesty prisoner of conscience that people are going to be sympathetic to. And so what I was wondering was whether these governments, particularly China, Russia, the major violators that you spoke about, Cuba, Saudi Arabia, whether they would in fact do something like that with a working group, find a way of bypassing them in effect.
Yeah. Well, one of the good things I've seen with smaller states is that when a working group opinion comes out the right way, and if you can put the right attention on it, smaller states will want to get rid of the case by getting the person out of jail, letting them go. The smart dictatorships will have a revolving door for imprisonment, right? And they'll give shorter sentences, right? So if you get only a 1 or 2 year sentence, given the working group takes like half a year on average to get an opinion, and then from there to ratchet up big political pressure takes more time, it's very, very hard to create a global sense of outrage if a person has a 1 or 2 year sentence, right? And so that's been one of my experiences is on cases that are where governments are just giving a person a year or two, the likelihood they're going to serve that sentence is quite high, because it's very, very hard to create the pressure to resolve a case, let alone to get people really upset about a case of a detention for a year or two, even if they're a political prisoner. The governments that do dumb things like give Nasheed 13 years in jail for a ridiculous terrorism offense, guess what? Draw all the international pressure and attention on them. And then when you combine it with all the ways they acted that were pretty outrageous, it only made it worse for them. So I definitely see the revolving door, like dictatorships like Kazakhstan or Turkmenistan, sometimes Russia, will give people shorter sentences. China doesn't seem to care at all anymore, so they'll do what they want to do. But undoubtedly, smaller countries that are more susceptible to the pressure from the UN and otherwise, often you'll see a prisoner who has been the subject of a working group opinion might get freed sooner than someone who's otherwise a political prisoner in the country. And so in that sense, the working group has shown its benefit. It's just you need, obviously, the working group to have more capacity to take on more cases and more people taking cases. And this is, of course, why I wrote the book in the first place, which is to be a resource guide for civil society activists, lawyers, and others. A number of people have asked me, do you think your book is going to help governments do a better job detaining people? Which is a good question, actually. And I thought about that before I wrote the book, and my conclusion was probably not, because as I described before, the working group generally does a pretty good job with its assessment of cases. And the reality is that, again, the working group won't substitute itself for a domestic fact finder, right? It doesn't, like, if they're dueling witnesses in a case, one saying they saw the person shoot the gun and one saying they didn't, they're not going to step in and say, well, we believe this account versus the other account. What they look at are violations of international law. So, for example, if in that case that I've just mentioned, if the weapon that was then recovered by the police, for example, no evidence was presented of a DNA test or like that showed that the person who shot the gun was in fact the person whose fingerprints were on it, right? And the defense, for example, introduces a motion to have the opportunity to conduct fingerprint tests on the gun. This is a very simplified example. And the court says, no, we won't let you do that, right? Well, that could be found to be a violation of the defendant's internationally respected, guaranteed due process rights. And the mere fact of allowing or not allowing an expert to examine a key piece of evidence is a violation of due process rights, and you have to see if there are enough other due process abuses to have it be to determine that a person has been held arbitrarily. But again, if it's a dueling witness thing, you're not ultimately going to prevail. So, but yes, I think that lots of governments learn about the effectiveness of doing revolving door detentions or really beating people up and letting them out. But again, I think it shows the power of the working group itself, because I've seen many, many cases where, if you were to look at any country which has, let's say, Azerbaijan and 50 political prisoners, the ones who will get out first are most likely going to be those that you have working group opinions on, because the governments wants to engage with the world. They want to be viewed as a responsible actor. They of course reject the opinion and they say it's irrelevant, but they understand politically it's a problem for them, and they're going to have it raised to them by many governments around the world. And therefore, unless it's a person who is, a potential future leader of the country and a big threat directly to the president of the country, who in those cases they'll just keep them in jail anyway until the political pressure dramatically mounts up. If it's a lower level activist, it's much easier for them to just let them go, and then they won't get any grief about the other political prisoners who aren't subject to the working group bans.
Great. We have to close so he can catch his flight. But let me suggest that you write down this coupon code, Genser 2019, so you get 20% off for the book.
I'm sorry the book is so expensive. I'm raising money now to try to get it free and publicly available for all who would like to see it. And so I have to raise $30,000 to pay Cambridge, my publisher, to make it publicly available. I've raised 10 and need another 20, but hopefully they'll get there
If
soon
you know
enough.
anybody who's willing to contribute that money, to contact
If somebody
you.
has
And-
$20,000 to spare, I'll take a check made out to Cambridge University Press.
Mr. Ross would be good. And you see ample evidence of why he's such an effective human rights lawyer, so please join me in thanking him for the wonderful work he does.